Hi, my name is Easton Lewis, and today I'll be continuing with Chapter 9, which is the Law of Contracts and Sales. At the beginning of this chapter, it describes contract law. And contract law is a legally enforceable exchange of promises or an exchange of a promise for an act. The sources for this law is case law and statutory law, which is also related to the Uniform Commercial Code, also known as the UCC. The chapter continues with the classification of contracts. One of the contracts listed is the express contract, and that is an exchange between parties or written promises that are enforceable. The next contract is the implied contract, which is a contract established by the conduct of the parties. This is followed by the unilateral contract, which is an exchange of a promise for an act, which is also followed by the bilateral contract, and this is an exchange of one promise for another promise. Next is the void contract, and that is a contract that at its formation has a legal objection or a serious defect. And lastly, the voidable contract is a contract that gives one of the parties the option of withdrawing from the agreement. Continuing with the classifications of contracts is the valid contract, and this is a contract that meets all the legal requirements for a fully enforceable contract. Next is the executed contract, which is a contract the terms of which have been performed. The last two is the enforceable contract, which is a contract that exists but cannot be enforced because of a valid offense. And lastly, the case contract, which is a court imposed agreement to prevent the unjust enrichment of one party when the parties have not previously agreed on an enforceable contract. The chapter continues with the elements of the legal contract. And these elements are listed as the legal offer, the legal acceptance, consideration, genuine assistance, competent parties, and a legal objection. The legal offer shows objection intended to enter into the contract. This is when courts consider words, conduct, writing, and deliberate omissions of the offer. It must be definite in nature, meaning it must contain reference to some subject matter, quality of items being offered, and the price of the items. And it also must be communicated to the offeree. The chapter continues with the methods of termination of an offer. These are listed as the lapse of times, the death of either party, destruction of the subject matter, rejection by the offeree, and revocation by the offerer. Next is the legal acceptance, and this has requirements of an intent to accept must be shown by the offeree. The intent must be communicated by proper means. The intent must minor the terms of the offer as well. And then next, it comes consideration within the chapter. And this is a bargain for exchange of promises in which a legal determinant is suffered by a promisee. The adequacy is the court's examining sufficiency and not adequacy of consideration. The pre-existing duty rule also goes along with consideration, and that is if a party merely agrees to do what he or she is required to do, there exists no determinant to the promisee. Continuing with considerations, courts have used the doctrine of promissory estoppel to enforce certain promises without consideration. The doctrine of promissory requires a promise justified relied on the promise by the promisee, and the substitutional economic determinant by the promisee. Lastly, an injustice that cannot be avoided accepted by the enforcing the contract. Next, the chapter describes the difference between liquidated and unliquidated debates. A liquidated debate, there is no dispute about the amount of other terms of the debate, and it allows a promisee to claim damages based on former agreements, even if the later agreement was acted upon the parties involved. Unliquidated debate is there's dispute between the two parties as the amount owned by the debater. The new consideration is given to the later agreement, and promisee no longer has claim of the former agreement. Next, chapter describes the promises of lack consideration, makes a list of them. To begin is the illusory promises. Next, the moral obligation, pre-existing duty, and lastly, a legal consideration. The genuine assistant is an agreement to a contract that is free of fraud, durances, mental coercion, and mutual mistakes. Factors that prevent genuine assistance is fraud, which is misrepresentation of material fact made with the intent to deceive the other party. The party relies on the misrepresented information and is injured as a result. The duress is a wrong act or threat that prevents one from exercising free when executing a contract. It includes threats of economic ruin or public embarrassment. Continuing with genuine assistance is undue influence, which is the mental concern exerted by one party over the other party to a contract. Requires a dominant subservient relationship between the involved parties, which allows one party to mentally conserve the other part. Next is the mistake, and that is the error as to the material fact. There's two types of mistakes. One is the bilateral mistake, which is the error is made by both parties, and a unilateral mistake, which is the error made by only one of the parties involved. Next is the competent parties, and the competency is the ability to understand the nature of a transaction and the consequences of entering into at the time the contract was entered into. Minors is contracts made by minors can be disaffirmed before he or she becomes a majority age or shortly therefore after. Failure to disarm a contract results in being ratified and is legally binding. Liability for the reasonable value of necessaries which enable the minor to live in a manner to which he or she is accumulated also relates to the minors. And continuing with the competent parties is insanity. If a person is adjunctionated by a court to be insane or is de facto insane at the time of entering into a contract, the contract can be disaffirmed, and it can also be disaffirmed by the court-appointed guardians. Intoxication is a person who is intoxicated to the degree understanding that a contract is consequences is impossible will be able to disaffirm a contract in all cases except those involving necessaries. Next, the chapter discusses the legal objection. And this is a contract subject matter that is lawful under statutory and case law. Statutory law is contracts made by unlicensed providers or services for which licensure is required and not enforceable. The case law is the standard of reasonableness is used to determine whether a contract is enforceable. Each factual situation is carefully examined. Next, contracts that must be in writing. Contracts for the sale of interest in land. Contracts to pay the debts of another. Contracts not performable within 1 year. Sale of goods that are $500 or more, and also non-business contracts. Next, the chapter describes parole evidence rule. That is when parties have executed a writing agreement which is complete on its face, or agreements made prior or at the same time that vary, alter, or contracted the written agreement are invalid. There are many types of third-party beneficiary contracts. Intended to beneficiary contracts is when two parties to a contract, either by words, writing, or actions, intend to bring benefits to a third party by virtue of an enforceable contract. Incidental beneficiary contracts is when no intent to bring benefits to the third party. Benefits is unintentional and the incidental beneficiary cannot sue to enforce such a contract. Next is the Donnie beneficiary contract, which promisee obtains a promise from the promisor to make a gift to the third party. And lastly is the creditor contract, which is when the promisee obtains a promise from the promisor to fulfill a legal obligation of the promisee to a third party. Assignments not recognized by law is also discussed in the chapter, and this is when assignments that materially change the duty of the obligator, assignments forbidden by the state statute, any assignment forbidden by the original contract between the obligator promisee and obligated promisor, and then contracts for personal service. That's all I have for this chapter. I thought this chapter was really interesting just because of the classifications, contracts, obviously not knowing all of these contracts and what they are used for and how they are used in the court of law. I just thought that was very interesting. So.